Okay, I think we're going to get the ball rolling since we have a fair amount to cover today. I'm going to give some introductory remarks and then we will get right into the substance. Welcome. Thank you for joining us for our webinar, Workforce 2.0, Navigating Legal HR in the Age of HI. Today, my colleague and I will discuss the use of AI in employment practices, relevant government regulations, and how to address employees using ChatGPT and other generative AI programs while working. My name is Lisa Koblin, and I'm a partner of Saul Ewing's Labor and Employment Practice based out of our Philadelphia office. I'm joined today by my colleague, Matt Cole.
Hey everyone, I'm Matt Cole. I'm a partner in Saul Ewing's Baltimore office. I lead our firm's AI team, and I also, in my spare time, litigate commercial matters, intellectual property matters, and do a variety of things with data privacy. And we're excited to present on this topic to you. It's very relevant and it keeps changing, so we've done our best to stay updated, but I think we should dive right in. So if we could move right to the next slide. So a little background on AI.
Sorry,
Oh,
Matt.
sorry. Oh, go ahead.
1 second. We're so excited because we have so much to cover. We will definitely get into AI and the many uses. Just a couple of housekeeping matters before we do that. Questions can be submitted through the Q&A tool at the bottom of your screen. While we will do our best to answer questions during the webinar, if we run out of time, we will definitely follow up at the Q&A session or via an individual email. So please feel free to submit any questions and we will definitely try to answer them throughout. This program is eligible for 1 distance learning substantive CLE credit in a number of states. In order to verify your participation and receive your certificate of attendance, you'll need to complete a brief continuing legal education verification survey and note the numeric codes provided during today's webinar. So yes, we will have codes throughout. I believe there are 2 codes. They will be part of the requirement to get your credits if that applies to you. And there will be a verification survey link that will be included in your reminder, that was included in your reminder email, and will also open automatically in your browser at the conclusion of the webinar. So also in the next few days, you will receive a follow-up email that will include the webinar recording. Yes, it is recorded. Yes, we will share it, and the presentation materials. So we will make those available as well. Finally, because obviously we're lawyers and we can't go a moment without a legal disclaimer, the provision and receipt of the information in this program is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts. And now, Matt, I turn it back to you to jump right in.
All right, thank you, Lisa. So let's just set the stage a little bit and talk about some terms and give a little background on AI. Artificial intelligence, there really is no universally accepted definition of it. Various state statutes throughout the country are using different definitions. Even statutes within a single state have different definitions, so it can be very confusing when trying to really assess whether the technology you're using constitutes artificial intelligence. But I like to think of it as a computer system that has aspects of human intelligence in that it can assess a large quantity of data and identify patterns, make decisions, make recommendations, apply rules to that information, and provide new and different kinds of output. AI has been around for almost, for over 70 years approximately. But when most people think about AI these days, they're really focused on generative AI, machine learning, and of course, ChatGPT and other large language models. But AI has been around, and part of our life before then, Siri and Alexa, right, our personal assistants, are a form of AI because they can curate, for instance, music lists or shopping recommendations based on our history, habit monitoring and social media feeds, of course, right, deep fakes, where you can take an image of somebody or an audio recording and have the program generate videos of that information to represent a real human, may not even be a real human, facial recognition technology, which is germane to our conversation today, self-driving cars, and of course, various strategic games. Next slide, please. So here are some other additional terms. We'll go into these a little bit without getting too technical, but machine learning is a term you probably hear quite a bit. A lot of the LLMs are based on machine learning, but machine learning is really an iterative process in which you feed information, you train a system, on data so that it can make decisions and predictions. So for instance, if you want your machine learning tool to recognize or understand the difference between mammals and fish, right? You could train it and submit to the system tens or hundreds of thousands of pictures of different kinds of mammals, tens of thousands or hundreds of thousands of pictures of fish. It will then recognize the different characteristics between those two types of animals. And of course, you can get even more specific differences between cats and dogs, et cetera, et cetera. But it's really about pattern recognition based on the data that it's trained on. Gen AI is a subset of that. It's a form of artificial intelligence that is used to create content. It can be written output, videos, audio files, audio-visual files, computer code. And you've probably seen a lot of this in the LLMs, large language models that we're all becoming very familiar with, both as lawyers in our personal lives. Lisa mentioned ChatGPT. There are a number of other LLMs out there, but LLMs really are based on predictions, right? They don't know anything. They're not optimized for accuracy. They're optimized for fluency based on patterns they've recognized in language, whether it's in a paragraph, a sentence, or some larger or smaller amount of text. You probably have seen the term hallucination. It's just when an LLM generates fictitious, false, or inaccurate information. It's just a limitation of all LLMs. It is a feature of them. It is not a bug, and it is something to be cautious about because you may notice that the more you use an LLM, the more hallucinations you're going to get, and we'll talk about that in a second. Another type of artificial intelligence that's relevant to our conversation today are automated or algorithmic decision-making tools. Those are AI systems that can make decisions or recommendations without human involvement, and they are becoming increasingly used in employment decisions, both application screening, resume screening, and even job performance reviews and promotion decisions. Next slide, please. And so here are some other terms that relate to the AI tools that you're using. Model drift, right? I mentioned that some LLMs may not be as good over time. That's because a model's predictive accuracy can change over time based on the data it encounters, right? It has a hard time sometimes going back and understanding and drawing context from prior instructions based on new data it receives. And it's something to be very cautious of. And we'll talk about some of the governance considerations if you're using an AI tool for employment decisions, because you may have model drift in your model, and it's important to monitor that. An impact assessment. An AI impact assessment is an internal process in which an organization looks at the various impacts that a AI model will have on its employees, non-employees, right, applicants for a job or a credit card, and also society at large. It looks at a variety of different considerations, whether they're intellectual property, data privacy, discrimination, and tries to really help an organization figure out whether this AI tool is the right tool for the specific task they've identified. A bias audit is something that's a little different. It's similar to an impact assessment, but it's really focused on identifying and seeking to mitigate the risk of discriminatory outcomes from an automated decision-making tool, and they are becoming at least required, at least in some jurisdictions. For instance, we'll talk about New York City Local Law 144, which requires an independent bias audit. That is a bias audit by a third party. So, a bias audit is something you have to do every year, and we'll talk about how to frame that out in implementing AI technology within your organization. And then fine-tuning and retrieval augmented generation, also known as RAG, are two technological techniques that organizations may use to mitigate the risk of hallucination. First, fine-tuning is training a model on very domain-specific or task-specific information. So in some, you take an LLM, right, which has the language capabilities, and you train it further, enhance it, optimize it on your company's data, on specific information that's relevant to a task. So for instance, if you are training a model for employment purposes, you may want to train it on or fine-tune it on employment regulations, local laws, handbooks, things of that nature. Whereas RAG is a different kind of technique where you connect your LLM to an external library of data, and that is where the output comes from.
So, Matt, just a quick question. How important would you say that impact assessment is when thinking if you're a company that's looking to work with a new vendor or bring in a new tool to assist with, obviously, we're talking about sort of HR systems and protocol, but how important is that impact assessment process
Yeah, I
to
mean, I
verify?
think it's highly important, even if it's for a low risk use, right? Even if you want to implement a chatbot internally or externally, chatbots hallucinate, right? They drift over time, and you really want to understand the level of risk that you are taking on by using any tool, and given sort of the increase in lawsuits and the potential for regulatory risk, an impact assessment is a written document. It's a documented process, and it's good evidence, that the company exercised reasonable care if you are faced with a lawsuit or some kind of, questions from a government agency. All right, next slide, please.
Okay, so we have our first CLE code here. I'm going to read it out loud. It is 93651. Again, our first CLE code for those who are interested, 93651. So, when we think about the integration between AI and employment, it's no secret that AI is, sort of taking over every professional space in a lot of ways. And in the context of employment practices, we're seeing it in resume screening, background checks, interviewing software, monitoring employees, monitoring, how often an employee is working. Are they actually working remotely when you think they are? Or have they figured out one of the systems where they can just move their mouse around every 2 minutes while they're watching something on TV or going for a jog? Computer-based skills testing, there's note taking, there's programs that can analyze employee surveys, right, and give you an assessment of, we reviewed this feedback very quickly, faster than a human being could ever do it, and here's all these lovely data and graphs that tell you exactly how your employees feel or view different subjects. They can create custom onboarding videos. If some of you may be using AI to even read aloud parts of policies as part of training because they sound so human-like that you can pick different voices and characters, and it sounds, incredibly realistic, which is also very frightening in a lot of ways. And of course, to analyze employee performance. And I think that it is certainly something that is evolving. It's not going anywhere. It's going to be part of what we're doing. And in a lot of ways, it can absolutely support management, HR, decision makers. And that being said, it's not without its risks, right? So we have to just make sure that for all the ways that we're integrating these programs, that we're thinking about the human oversight of those programs. And we're not just having a set it and forget it mindset, or assuming that a program is doing something or taking care of something without checking and doing those periodic audits to make sure that it's in line with our practices, just the way that we've seen with payroll software, right? We set up through whatever your payroll platform is, that you're going to have these different codes that record for overtime or commission or bonus. And a lot of times we find that we think we've set up everything correctly, and then lo and behold, we get that complaint in the mail, and we find out that there was something wrong with the process where things were not set up as we thought. So it's a similar mindset here. And so we just don't want to forget about human intervention and oversight. Next slide, please. And with that being said, Matt hinted on this earlier, and it's no secret to any of us in this space that with everything related to HR, employees, hiring, promotion, firing, terms and benefits and conditions of employment, there's always a thought of, okay, how does this create any legal exposure, any legal risk? We're weighing the pros and cons. And of course, we want to have tools that are going to enable you all to do the work that you set out to do, to make more money, to be profitable, to be productive. And we want to make sure that we're keeping in mind that this is going to be one of the new waves of employment litigation. We're going to talk about some cases that have come up in the news recently and what that signifies for the future. But this all stems from federal, state, and local law. So under Title VII, of course, that is the federal law that prohibits intentional discrimination or disparate treatment in employment, which includes employment tests that are designed, intended, or used to discriminate based on protected categories such as race, color, religion, sex, or national origin. So in that way, Title VII has been interpreted historically to prohibit employers from using neutral tests or selection procedures that essentially have the effect of disproportionately excluding certain populations, right? So you have a test that looks neutral on its face, and it turns out that as a result of that test, certain populations are excluded. We have a caveat here. So there's been many changes to, the way that the EEOC is handling a lot of things in the employment space under the current administration, and disparate impact is one of those items. So the current federal administration is not pursuing disparate impact discrimination cases through the EEOC. There was a executive order that was put out a couple months ago on that topic, which we could probably spend a whole presentation on, but suffice to say, I think we all are aware, but just as a reminder, that does not mean that there is not case law out there that says disparate impact discrimination is illegal. That does not mean that plaintiffs will still pursue this theory until they're told under a change in law, rule, or regulation that they're not allowed to do that. So there is absolutely a gap and distinction between the platform and the perspective of the EEOC or the federal government and how it's operating, and what has been in existence for decades in terms of interpretation of Title VII. So it's not going anywhere anytime soon. Next slide. So I just mentioned that we're going to highlight a couple examples of cases that we're seeing pop up in the news, because this really highlights what is to come. Obviously, there's a lot of nuance here. There's going to be, not every state, a lot of states are working on their own legislation, if they haven't passed it already, to sort of try to wrap their arms around this moving target that is AI, which is constantly changing. We know the law may never be fully caught up, but they're trying to put in some rubrics and some parameters. And the latest sort of nationwide case that probably a lot of you have heard about is earlier this month, a new class action lawsuit was filed against SiriusXM, which alleges that Sirius used algorithmic decision-making tools, including AI and machine learning, through another vendor to screen and reject applicants for the purpose of disqualifying African Americans from securing employment. So that's the allegation. Of course, this complaint was just filed. This has not been litigated yet. There's a lot that remains to be seen. But some really key takeaways here are that the class is intending to hold Sirius liable for working with a third-party vendor. And that's really what comes up in a lot of these lawsuits. So, in states that have passed laws, and we'll talk about some of those, the company is not off the hook just because you didn't create the program, you're not the mastermind behind the AI technology. Perhaps you signed a contract with the vendor and they told you left, right, and center, oh, we do everything by the book, we've checked, and just take our word for it. We do a really good job in making sure there's no discrimination, right? Even if that's the case, the employer can be held liable potentially for working with and using a vendor to screen applicants if it results in this disparate impact discrimination that we've been talking about. So in this case, the plaintiff is an IT professional who apparently applied for about 150 positions with Sirius, and he received only one interview. And so what he's claiming is that Sirius used certain data points to screen candidates based on race in a way that didn't seem like they were screening based on race. So what do we mean by that? Screening based on zip code in a way that perhaps disproportionately screened out certain populations that maybe tend to live in a certain area. Looking for certain codes in terms of employment history and educational institutions. So if I say, I really favor this university or these universities in this state, or my alma mater, if your alma mater or those universities have a population that is primarily white, then you may be disproportionately impacting people of color or other populations, right? So again, this is not a situation where they're using tests that say, hey, we're going to screen out these people. Of course, it's never going to be that black and white, but this is why when Matt talks about doing the bias audit and the impact assessment, we have to really think about, you're signing these agreements, you're looking for these services that are going to make your lives easier because you receive perhaps hundreds or thousands of applications. it's, you need programs that are going to help you work through it, but not all vendors are created equal. And again, that's not to say there's been no decisions in this case, but we're going to see the floodgates open on these cases, just like we've seen, when COVID hit and when there were other new and emerging issues in employment law. And I think the only other point here is that the plaintiff was also saying that basically the algorithmic decision-making tool was trained on data reflecting historical inequalities. So it's another underlying concept here, is that it not only is highlighting certain data that might tend to select candidates that are not African American, but maybe even making assessments based of the African American candidates that indicate that they have certain qualities that are not on their resume, or making assumptions or drawing distinctions about those people and those populations that have nothing to do with any actual information they've been provided. It's just part of the decision-making tool and how it operates. Next slide.
Here's another lawsuit, a recent update that sort of takes the opposite approach, in that it's the agent of the employer that may be on the hook for using AI in the employment context. And, the real takeaway from these cases, and as we get into some of the state laws, is that you have exposure if you're both a developer and a deployer of AI, right? It goes all the way up basically the chain of commerce to the ultimate user, and you really can't point your fingers at the system and say, it's not me, it's their fault. That's why you have to have really strong contractual provisions, and we'll talk about that in a minute too. But here is a case that was filed last year against Workday for providing software that allegedly discriminated against an applicant based on race, age, and disability. Last summer, the court denied a motion to dismiss, and just a few months ago actually granted conditional certification of a class under ADEA claims, and determined that Workday was an agent of the company for which it provided its AI tool, because they performed a traditional hiring function of rejecting candidates at the screening stage. So, the real devil is in the details, and you really have to get a good understanding of what tool you're going to be implementing, and really press your vendors hard for background on it. Ask them the questions: have they done their own bias audit, and can they share it with us? And then you take that information, right, and you do an impact assessment, and you look at all the information holistically. And if the risk of potential lawsuit, or you can't really explain, for instance, how the tool is arriving at certain results, right? Always good to demo a tool before signing the agreement. You note all that on your impact assessment, and probably check the "no, this is not for us" box. Let's find another vendor. But this case really highlights that it's not just deployers, it's also developers of the AI tool that could be found liable for violating anti-discrimination statutes. Next slide, please. And another recent case is Brewer versus Otter AI. Now, this is a case that was recently filed, and the claims that were asserted relate to privacy statutes, but they certainly have HR implications. So a lot of you may be familiar with Otter AI, right? You go to Zoom meetings, and the person on the meeting with you see automatically pops up, Joe's Otter AI note taker. And you got to kick that Otter AI out of the meeting most of the time, because you don't know who they are, who sent them, what information, where they're going to keep the information. But the allegations are really about consent and secretly recording conversations, and then maintaining those transcripts, which may have confidential business information, personal information, for use for Otter to further train its note taker tool. So although the privacy claims are really front and center in that case, it's relevant here because it's a concern when your employees are having a virtual meeting, and one of them invite, whether internally or especially externally, with like a project partner or a vendor, right? They discuss confidential and sensitive business information. You don't know where that data may live, who may have access to it, how it's going to be utilized. You really want to vet your vendors, train your employees on when and when not to use AI note takers, can be part of a formal AI training. You may want to implement provisions like this into your formal written AI use policy. And oftentimes you may want to have like a canned statement or a script. So if your employee sees someone come to the meeting and have their or want to use an AI note taker, you obtain their consent, give them notice that you're going to be using it, so that um, reduce the risk of being sued for the kind of claims that you're being asserted in the Otter case here.
And
Next slide, please. Oh, go ahead.
sorry, just Matt, on that note, and along those lines, we want to be really thoughtful about when we want note taking to be available from the perspective of not all meetings should be recorded. And well, first of all, like meetings with your attorneys, right? We don't want to see that, or AI. We're going to politely decline to have our meetings recorded, which I know is just sort of like an auto function. But for HR, especially if you have any of those settings where it's sort of auto recording, or you're thinking, this is great because it'll help me take notes and I'll get a summary. We want to be thoughtful about, we want to have control over how those meetings are recorded and what is recorded. And yes, of course, we want accuracy. We want the truth. We want to make sure that we're clear about who said what. But we want to be thoughtful about that recording function. And if HR is not involved, I think there's still even a distinction about when these programs should be used, right? Because it could be a performance review, or it could be something like Matt said, where there's confidential information that is shared that's highly sensitive, and then who has access to that information, where are the notes stored. So it's really this multi-layer thought process. And again, we fully appreciate that nobody wants to create a transcript of a meeting, and having a summary readily available and having information broken down into bullet points at the click of a mouse is amazing. And there is a time and a place for that, but it might not be all the time. Or if we are doing it, what is our process for allowing that type of programming? Next slide. So another example, and this is one that was about 2 years ago now, but I think it's still just worth mentioning, this EEOC lawsuit, and this was under the Biden administration. But just as an example of, this is what we can expect from our state fair employment practice agencies, right? So whether or not the EEOC is pursuing AI related discrimination claims is, remains to be seen how aggressive they are on those fronts. But at the state and local levels, you can be sure that if they don't already have a law in place, there's a lot of states and cities where they're going to be aggressively pursuing these cases, just like any other disparate treatment or disparate impact case, right? And in this case, the EOC sued an employer claiming that they used application software that automatically rejected female applicants over the age of 55. And essentially what the plaintiff said is that they applied they applied with their real birthday many, many times. They were rejected. Then they submitted their resume, and the only thing they changed when they resubmitted was their birth date to make them younger. And upon doing that, lo and behold, they were allegedly selected for interviews. And that resulted in a settlement of $365,000. And, certainly there's going to be a range of settlements and implications from these lawsuits, but this one is already in the books, and it's sort of an initial playbook, right, for the other state agencies that might be pursuing those claims.
And I'll say one interesting thing about this case is that the complaint didn't specifically allege the use of artificial intelligence, but it referenced algorithms. And an algorithm is not necessarily a feature of AI, but it's certainly associated with that term. So it's just something to be aware of, that even if it's non-AI specific software, right, just the risk of algorithmic discrimination is still, or algorithmic discrimination lawsuits is still out there.
Next slide, please. So we want to highlight some examples of recent legislation that has come into play regarding these issues. Again, these are just snapshots. It's not everything. There are bills pending all around the country. There are, legislators are actively working on AI related legislation that is either directly related to employment or indirectly related to employment in states all over the country, regardless of their red or blue, purple, whatever they may be. This is something that is in the works that's being heavily discussed. So as an example, the California Civil Rights Council recently adopted final regulations, which are going to affect in October on this very subject, which are going to be impactful for anybody who has employees in California. Like other employment laws, these rules do not, it doesn't matter where your corporate office is located, or you know, where you register to do business. This is if you have employees working in the state of California, and if you have 5 or more employees, this is something you're going to want to pay attention to. So it's the regulations, I think, were maybe 40 something pages, and they're updates to other existing laws, but essentially it confirms that automated decision systems can violate California law if they harm applicants or employees based on protected characteristics. There's going to be certain requirements about maintaining records related to automated decision data for at least 4 years, and affirms that automated decision system assessments, which include, I have another slide with other examples, but tests, questions, puzzle games, other programs that elicit information about, for example, a disability could constitute an unlawful medical inquiry. So it's pretty broad and all encompassing. And notably, the law also considers, so if there's an incident where an employer may be using or alleged to be using some sort of automated decision system that perhaps somebody is claiming was discriminatory, the law instructs that decision makers will consider relevant evidence or lack of evidence of anti-bias testing or similar protective efforts to avoid discrimination, and including, the scope and extent of those efforts. So essentially, if you are, working with a vendor that is providing these services, and you're not double checking, you're not going through the steps of doing the bias audit, the impact assessment, the reviewing, the, doing the test, the demos, looking at the data before you launch it, right? To see, you can do sort of a test program typically before you're actually going to launch and use it in real time to see what the results may be and doing your research. If you're skipping those steps, then you're more likely to be in the hot seat and perhaps be a test case for new litigation that is going to come out of these new legislation. Next slide. So in this context, in California, an automated decision system could be any sort of computational process that makes a decision or facilitates human decision making regarding an employment benefit. So again, circling back to when we're using these systems to sort of act like or support human HR, human decision makers in making decisions about terms or conditions of employment. So we're measuring an applicant's skills in real time or their abilities. We are directing recruiting materials to certain targeted groups, screening resumes, analyzing facial expressions, analyzing employer applicant data from third parties. So it's fairly broad. That it does carve out sort of generalized technical functions such as word processing, spell check, any sort of antivirus software, website loading. So it's not literally any computer program that you use. Of course, there are parameters, but it's targeting these types of tools that are actually involved in the decision-making component. And the law says that if you are a covered employer, you shall be held liable if you or any of your agents use an automated decision system that discriminates an applicant or employee based on a protected class. So that means our managers, our supervisors, our agents. And that brings us back to, do we know who is signing these contracts? Do we know what systems they're using to vet these programs? We should not assume that, let's say you have a head of IT, that they're going to have an HR employment law lens on the program that they're vetting for you from a technical standpoint. What team do you have working together to make sure that the system is serving you correctly and not just opening a can of worms or going to put you in hot water? And the examples that keep coming up are, and we saw in the serious case, employers who are using programs that are screening, whether known or unknown, based on zip code, based on where somebody went to school, based on even social media content, right? So you might think that that is innocent enough, or you want to know if somebody in their social media is extremely unprofessional, if they're sexist, racist, what have you. And that all sounds really great on paper, but what is the actual data that they're extracting and assessing to make the decision that somebody is the right candidate for you or not? You want to really get into that level of detail to understand how these systems are operating. Next slide.
Oh, I just want to add to the last point you raised there, Lisa, about social media. There have been some like surveys and studies that come out, and it looks like the majority of data on which LLMs are trained on are Reddit user feeds. So if your system is 60% Reddit user feeds and your vendor is not willing to tell you that, you may want to find a new vendor.
Well, we all know if there's nothing more reliable in this world than Reddit, right, Matt? We all love Reddit. So just a couple other examples here of these are laws that have already been passed and one that is going into effect shortly. So in New York City, this is really a a piece of legislation that is I think to be expected out of New York City, I guess I would say, but it's extremely employee friendly. It's very tedious and requires a lot of steps from the bias audit standpoint. But if you're using certain AI programming and hiring and job promotion decisions, you must use automated employment decision tools that are approved, or the process that's approved by the city, which requires a bias audit, and it requires it annually. So the law sets out what they consider to be a bias audit, which is through a third party neutral bias auditor. What sort of data, what sort of historical data the auditor can use to make that assessment, what data needs to then be published to your employees, because yes, that data is going to be shared and published in certain circumstances. The information you have to share with applicants and employees if you're hiring or doing a promotion, it's very detailed, and yet, like everything else we see come out in these FAQs and these regulations, there's still confusion because they're not gonna be able to answer every question at one time. So there are FAQs, there is information on this, but it's still a newer process that requires a lot of attention and a lot of dotting our I's and crossing our T's. So please know that this applies if you have employees who are working in New York City. It does not matter if they are sitting in a physical brick and mortar office or if they're working from their home office. If they are working in New York City at least part-time, these requirements may apply to those employees. Illinois has a new law going into effect in January 2026, HB 3773, which amends the Human Rights Act, which prohibits using AI that has the effect of subjecting employees to discrimination on the basis of protected classes under the law. It requires employers to provide notice that the employer is using AI, and it has extended protection to recruitment and hiring to cover applicants, of course, and talks about potential remedies. So, this is just one example of a new law coming into effect, and it applies if you have one or more employees. Interestingly, Illinois does not specifically require a bias audit, but at the same time, the question's always going to be, okay, if you are comfortable using these programs and these tools, how did you reach that determination? How can you be sure that they're not inadvertently discriminating against protected classes? And that's something that you want to ask yourself at every step of the way, right? So, we see, I know that there's a bill pending in New York State. There was a bill that was recently shot down in Connecticut, but we're just seeing these pop up all the time. So it's important to stay tuned to what's happening in your area. Next slide.
Yeah, and so speaking of staying tuned, right, this is a slide on Colorado's AI Act. It was the first comprehensive US-based AI legislation in the country, and it's supposed to have gone into effect, and now it's been delayed for until June of next year to allow for revisions. But here the focus is on high-risk systems. In that respect, it's similar to the EU's AI Act, where high-risk systems are those that can deny important services to consumers, so employment, education, housing, healthcare, insurance, financial services, et cetera. And so it has standards for both deployers and developers. And it's almost like a product liability statute in the sense of reasonable care, right, is the standard. When a reasonable company used the tool in which they did not do an impact assessment to determine if someone has access to employment. Probably not, right? Was it reasonable for a company to not tell an applicant they were interfacing with an AI system as part of the application process? Probably not. And so that's the lens you have to think about the AI Act, if and when it goes into effect and what it's going to look like remains to be seen. But disclosure is an important part of it, and really implementing risk management policies that address AI. And so I know Lisa and I have talked about impact assessments and bias audits and several times so far. This statute, as written, would require annual impact assessments, and they are becoming a more common in statutes. The EU AI Act requires assessments, and so even if where you're operating, you're not under the AI Act here or another similar statute. I think Virginia has a statute. I think they have impact assessments as well. Texas might. It's just a best practice, a good governance practice to start doing if you're not doing them already, um, even if they're not, required by a state statute where you're doing business. So think about this not just from the terms of what does the statute require, but what governance practices should I implement? Because there are going to be lawsuits, as we're seeing. They're going to start, I believe, getting more and more frequent. And you really want to have documented everything in a meticulous way, so that when you are sued, right, and discovery takes place, you can show a very robust impact assessment that you check the box in all these considerations. And bias audits, like New York right now, New York City is the only jurisdiction I'm aware of that requires a bias audit. And then they do serve different purposes. And dealing with AI vendors, sometimes they're reluctant to give you information about their tool. But I have started to see more and more of vendors using bias audits that they've done themselves as a marketing piece, right? So whereas I think in 2023 and 2024, companies were reluctant to disclose information about their AI tool to customers, now if there's so many players in the marketplace, they have sort of changed the perspective and are using their own bias audits as advertising. And so if feel free to ask. You should definitely ask your vendors for that information and include it, right, in part of your AI impact assessment. Has a bias audit been done? What kind of data does it look at? Does it look at some kind of historical data? Is it based on a small sample? How was it tested, et cetera? It really is becoming a very technical exercise to comply with some of these statutes, especially when a bias audit and you have to demonstrate you are not violating any kind of disparate impact. You have to do statistical analysis. It can be very challenging, and that's why it's going to be harder and harder to implement these systems if you don't have somebody with a technical background or know-how that sort of monitors them after they're being used to identify issues as they arise, because they may arise from time to time. Next slide, please. So algorithmic discrimination. So here, taking all the statutes we've seen so far, let's just get down to some common themes that are in them, right? Potential liability on employers and developers. Implement good governance policies, written policies, train your employees on them. Impact assessments and audits may be mandatory, but you should do them anyway to avoid the risk. Disclose use of AI to potentially affected individuals, applicants, customers, et cetera. Give your applicant the right to opt out of algorithmic decision-making tools, and of course, develop a formalized approach to managing AI risk. Next slide, please.
So we want to touch on briefly, because we have a few slides left that are, have a lot of substance. So I want to make sure we get to everything, ADA and reasonable accommodations. Before touching on that, though, just one other point to make is that when you are thinking about all these fun and great tools that your vendors and service providers are sharing with you in terms of using AI for HR related functions, including contracts, policies, handbooks, monitoring employee time, accommodations, things like that. It is still important to, when we think about human intervention, like the layers of that, I have seen some circumstances come up where I think that, you should pay attention to the disclaimers on a lot of the platforms that are providing these functions, which say, this is not legal advice, and, be sure to double check, because while they have access, faster access, as we all do, to what is, the law of this state or this city, it's not always being shared in the context of your industry, your workforce, how that plays with the other federal laws or state laws that are impacting what you do. And I've seen situations pop up where you may be thinking, I'm getting this service from a provider. I've already paid for this service. I want to cut down my legal costs, and we do appreciate that. And so I'm going to use this template or this product that I've been given, and it's been incorrect. It's been wrong, and it's had information that is not complete, that, a release agreement missing really critical information, policies that are inaccurate for the groups that they're intended for, missing information, or information that's inconsistent, or still using kind of boilerplate terms that don't make any sense in the context in which you need them. So, just be sure to really be thoroughly double checking what you're getting, what you're using, what you're sharing with your workforce. Okay. In terms of ADA and reasonable accommodations, we all know that, we have to provide reasonable accommodations to employees who have a disability, in terms of, it could be an applicant or an employee, to allow them to participate in the hiring process in a way that doesn't create an undue hardship for us, or to otherwise enable them to apply for a promotional position and things of that nature. And using these programs is no different. We need to ensure that, any tests that we're having applicants or candidates use for a position, that there is enough information provided to the recipient that they can make an informed decision of, I think I might need help doing this because of my disability, and I need to reach out to the company, to the employer, for assistance or for an alternative testing method. Because if we're not sharing that information, and we're unintentionally weeding out potential applicants because they have a visual disability or a learning disability or something that we could actually accommodate, that it's really just this one type of test or one program that actually isn't job related and they can do the job, that's a problem. Not only because we could be missing out on great candidates, but it's going to, certainly give rise to potential legal exposure. Next slide. So, we're going to share the slide, so I'm not going to spend a lot of time on this, but obviously suffice to say that with any sort of platform that you're using to be, to interact with candidates or applicants for a position, or current employees for a promotion, we need to just be sure that we're not just making decisions solely based on, for example, a speech pattern that is detected by the program, or using software that a vision impaired employee would not be able to use. And, we need to think about alternative approaches and have those available so that individuals with disabilities will have, equal access to apply for these positions. Next slide. When we think about monitoring generative AI usage long term, we want to limit the use of generative AI while performing work to only specific tasks with manager approval. So I think everyone knows this, but just to maybe state the obvious, all of your employees are using AI. It's a matter of, do you know how they're using AI, and do you approve of the programs that they're using and how they're being used? Everybody is using technology to try to, just in the case, in the most generous light to the employee, they're trying to do work that makes them look the best and sound the best and perform the best, right? That's the most generous interpretation. And in some contexts, that may be okay. You may think it's great that they're using a program to, write a marketing campaign, or run a report with an assessment of, certain performance of your operations, and that's fine. But what we don't want is people going rogue and using programs that we don't know about, and then sharing your company's data or information with those programs, and definitely not in ChatGPT, in a way that we have no control about it, right? And so again, just thinking about what content we're approving, how it's approved, that our employees know that there's a process of using certain programs and using them with approval. And we're making sure that we have, we're doing our best to control, the ever-changing landscape that is AI to the best of our abilities. Next slide.
All right, so before we jump into this slide, I'd like to read off the CLE code number 2, 47205. Again, that second CLE code is 47205. So what does this mean for your organization when you're at the part, right, of your AI journey, when you're going to start implementing AI technology, if you're not going to be using publicly available platforms, but you want to take on some kind of enterprise or some kind of software license for an AI tool, right? We've talked about AI impact assessments. We've talked about bias implications. So really, you need to do a good amount of diligence before signing that agreement. Coordinate with your procurement personnel, request information from your vendor. You can have a standard form, like a lot of companies have like a SaaS agreement diligence form or questionnaire. You can create an addendum specific to AI considerations, much like you have a cybersecurity contractual addendum. And you can also address bias and discrimination in the AI contract to give yourself some comfort that the party you're dealing with, that your vendor, has done enough to try to identify and mitigate risks. Now, all AI systems have known and unknown risks, so you can only do the best you can do. And that's why, thinking about the Colorado statute, right, it has a reasonableness standard. But you want to get reps and warranties on system performance and output quality from your vendor, right? And tie those reps and warranties to specific metrics or standards, such as impact ratios. You could use language from the local law in New York City, 144. Take that information that you get from your vendor, incorporate it right into the reps and warranties, or append it as an exhibit to the agreement. So that's part of the document, because your vendor should stand behind the statements that they make about their product. And so you want to have reps and warranties that the vendor has done testing, that their product and their output complies with best practices for transparency and fairness, that they've tried to identify bias in the training data and the algorithms, two places, right, where bias and can live. You want to have fulsome and AI-specific indemnification sections, right? Indemnification sections in AI contracts have AI-specific provisions, not just intellectual property and infringement, but you can also have things like indemnification for violations of anti-discrimination statutes, consumer protection statutes, among other AI-specific risks. You may want to have caps on damages or super caps on damages arising from high-risk uses, such as the use of an AI tool in the employment process. And you want to have audit rights. And auditing an AI tool is very different or more complicated potentially than auditing your typical like SaaS agreement product. You're going to want to request a variety of information, such as the testing methodology, getting the results, really understand how the tool is being trained, and try to what validation your vendor has done on their end to identify and mitigate any risks of discrimination, bias, or other unfair outcomes. Next slide, please. We've talked about this a little bit, hinted at it, but really compliance through governance is key, right? Organizational governance, right, should be tailored to your organization's risk management profile, the use cases that you've identified. Often as outside counsel, I'll get brought into the process after an organization has already signed the agreement and said, we've signed this enterprise license. How do we use this? We think we want to use it for this purpose, right? Flip those, identify the use case, do your diligence on the product, and then sign the agreement. And that should all be laid out in your AI policy. And there's always, your written policies, AI use policies, training, adopt the best practices, right? Have an AI task force of subject matter experts from different functions. So HR, legal, data privacy, information security, even marketing and finance, right? Depending on the potential use cases that you have identified for an AI tool. But here, obviously, you want to have your HR and your legal folks involved for the employment context. Implement written AI policies. They are new and different in some respect, but they have the playbook of data privacy and cyber and IP and data loss prevention. You can build off of those and complement those. Your policy should identify use cases and including what is prohibited. For instance, using AI tools for defamatory, discriminatory purposes. You want to clearly prohibit that and then have accountability for such violations, such as termination. And of course, you want to get buy-in from your employees, right? And your policy may even talk about things like doing impact assessments, bias audits, vendor diligence at regular timeframes, annually, but also as needed if an issue arises. And that will tie into your audit rights and your troubleshooting rights when dealing with your vendor. It really is, not just, at least I use the phrase, set it and forget it, but you really have to think and plan when you're using AI tools for potentially high-risk uses. And then next slide, please. Impact assessments and bias mitigation, right? We talked about it a little bit, but just want to reiterate it because they are so important, and not a lot of organizations do them, but there are vendors out there that will help you do this. Right? The goals of an impact assessment is to really understand how the AI tool can provide value, but also identify a variety of risks. You can look at a variety of metrics, both quantitative and qualitative, right? What data is it trained on? How much data? Is it good data? Is it bad data? Has it been enhanced? But also other things like who owns the data, or is personal information being used in the system? All the risks that could roll down to you as a potential deployer of an AI tool in an employment context. You want to understand that, right? So does your vendor have permissions to use that data? Will they represent they have the necessary licenses, right? So that way it's easier to negotiate, right, for indemnities and other protections for yourself. How many models are they using, and will they identify them for you, right? A lot of newish AI tools are not just here's ChatGPT, here's Claude. It's now multiple models in sequence because the models will have different strengths and weaknesses, better at certain kinds of research, better at certain kinds of language fluency. If you want to use it for a very specific purpose, right, you're going to then customize that model with your own information. So you really want to understand, the technology that you're going to be deploying within your organization and allowing third parties, right, to utilize, as well as your employees. Geography, where is the AI system developed and deployed? What type of output is expected? How will it be used? A lot of AI contracts, right? So there is really no standard form of contract in the AI space, but vendors will disclaim all kinds of liability for the accuracy and especially the reliance on output that their customers use. And you want to have oversight of AI development, as your AI program becomes more mature. It's not just necessarily, licensing an AI system, it's licensing and customizing, or a buy and build hybrid type situation where there's fine tuning or RAG, which we mentioned earlier. So you want to understand, where the data is coming from for that optimization and customization, and then impact on the bias data on individuals, groups, and society at large. It's not just your employees, it's not just applicants. Impact assessments look at other concerns that may not be necessarily relevant here, but like ESG considerations can go into your impact assessment. So it really is a holistic, comprehensive approach when identifying the known and unknown risks before deploying or somewhat developing and customizing an AI tool. And I think we're almost at the hour today, and I want to thank everybody for attending. But before you leave, there's a few closing remarks. I just want to thank Lisa and our attendees for their participation. Our team just added the survey link to the chat box, so please remember to keep an eye out for the thank you email with the program materials and the CLE verification survey so that you can submit the reporting codes from today's webinar. And of course, as I mentioned, I lead our firm's AI team, and every quarter I have a quarterly AI roundtable for in-house counsel. So if anybody would be interested in joining that, please feel free to reach out. The more the merrier. And thank you for your time today.
And if you have any questions, we'll hang on for a few minutes and are happy to discuss those, or you can email us and we can talk about them separately.